Good morning. I'd like to officially call this meeting of LNO to order. Madam Clerk, please call the roll.
Representative All.
Here.
Representative Banta.
Present.
Representative Callaway. Representative Kleins. Representative Dietz.
Here.
Representative Donworth. Representative Pfister.
Here.
Representative Flannery. Representative Gentry.
Here.
Representative Hampton.
Here.
Representative Hevron. Representative Huff.
Here.
Representative Jackson. Representative Kulkarni. Representative Meredith. Representative Neighbors.
Here.
Representative Raymer.
Here.
Representative Smith. Representative Wilson. Chairman Cook.
Here, we have a quorum. We're constituted to do business. Representative Hevron, who do you have with you today?
Thank you, Mr. Chairman. I have Mr. Jack Johnston. He is a constituent from Litchfield. He's in 5th grade at Lawler Elementary, and he's accompanied by his mom and grandma. And it's very special because I grew up with his mom in Litchfield. So please make Jack feel welcome.
Welcome, Jack. Okay, we have full agenda, so let's roll.
Thank you, Mr. Chairman. Jason Nemus, House District 33.
Thank you, Mr. Chairman. Shelley Punky Fromeyer, Senate District 24.
And I'm Mary Catherine DeLoder with the Kentucky Birth Coalition.
Welcome back, everyone. This is pretty exciting. How many years in a row have we done this one?
This is the last one.
Is this 5? Okay, so pretty excited. Floor is yours.
Thank you, Mr. Chairman. This is House Bill 90. Senate Bill 17 is an exact replica. We're talking about 90 today. And I think this will be the last time we're trying to get this bill through this committee. We've been here a number of times. Worked very
Second.
We have a motion and a second. If you could just briefly go through your changes to guide us to the agreement.
Okay, so we've required a transfer agreement. We have there has to be insurance. There is a proximity to the hospital. Informed consent are the main differences that were made, and it has to be credited for ACOG by ACOG's levels of accreditation. And that go ahead. Physician medical director, thank you. And so those are the things that got Hospital Association to be neutral on the bill. They don't oppose it, and there you have it.
And it's fair to say that everyone is for this or at least neutral on this.
I'm not aware of anybody that's against it.
Okay, there's been a motion, a second. Are there any questions? Clerk, please call the roll.
Representative All.
Yes.
Representative Banta.
Yes.
Representative Callaway. Representative Kleins. Representative Dietz.
Yes.
Representative Donworth. Representative Pfister.
Yes.
Representative Flannery.
Yes.
Representative Gentry.
Yes.
Representative Hampton.
Yes.
Representative Hevron. Representative Huff.
Yes.
Representative Jackson. Representative Kulkarni. Representative Meredith. Representative Neighbors.
Yes.
Representative Raymer.
Yes.
Representative Smith. Representative Wilson. Chairman Cook.
I'm a yes. Bill carries. Congratulations.
Thank you, Mr.
A
Chairman.
lot of hard work and compromise to get there, and appreciate that. So good job, everyone.
Thank you very much.
Thank you, Chairman Cook.
Okay, we're going to bounce around a little bit. We have 2 senators with us. Let's go with Senator West first with Senate Bill 65. And our good friend, Representative Lewis, who might as well be appointed to the committee at this point. Just introduce yourself for the record, and the floor is yours.
Thank you, Mr. Chairman. Steve West, District 27.
Thank you, Mr. Chairman, members of the committee. Derek Lewis, State Rep, District 90.
Thank you. Glad to be here today to present Senate Bill 65. If you've been here in the legislature for 5 years or more, you can kind of go to sleep at this part of the program. Senate Bill 65 has passed both chambers 5 years in a row. We are both co-chairs of the Administrative Regs Committee, and in essence, when we started on the committee, we had the idea that our committee only has so much power. We can find a reg deficient, or we can ask the agency to defer, and so we felt that we needed to hold the cabinets accountable, and so we started filing Senate Bill 65. And simply what it does is any reg that's found deficient through the reg process throughout the year, we meet every month, that reg is found null and void by statute, and that helps hold the administration accountable. And important to point out, this is not a huge power grab for the legislature, because we've reviewed hundreds and hundreds and hundreds of regulations over the year, and in this particular year so far, we've only found two regs, one subject matter area deficient.
Motion on the bill?
Second. Second.
We have a motion and a second. Are there any questions? Representative Gentry.
Good morning, guys. You said there's only one, possibly two areas. Can you tell us what they are and why they were deficient?
I'm going to hand it over to my co-chair.
Certainly, Representative. So as my co-chair mentioned, we work throughout the year, and oftentimes it doesn't come to a deficiency just because we can usually get the agencies to work with the parties involved to work out a solution, a resolution. In the case of this bill, we have two regulations affected, 907 KAR 1044 and 907 KAR 015005. These were dealing with behavioral health regs for Medicaid, and they were filed in November of 2023. Went through a public comment period, and they amended comments, I believe, in February of 2024. Now, during that time, the agency asked to defer, which means they push it back to the next month 8 times. And we tried working with them, but essentially it was going to require counselors to have master's degrees, which of course is a challenge in rural areas, right? So several entities reached out to us. The one that reached out to me in particular was Mountain Comp. And so they were already struggling at the time to find counselors to be able to service the areas. This is mainly impacting rural areas. So if your employees are all of a sudden having to go get a master's degree to do what they've been doing essentially the whole time, to treat individuals with mental health concerns, that was detrimental to them. It was detrimental to the employers just because they couldn't find the people, and then also having to pay a higher rate for the people. And then lastly, it's just an access to care issue for patients, because you're not going to be able to find counselors and people aren't going to be able to seek treatment. And so that's why we ultimately found the regulation deficiency under the basis of appears to impose an unreasonable burden on government or small business or both. And so that's why we found it deficient.
Just one quick follow-up. And remind me again what the purpose of Senate Bill 65 is. I know it's passed 5 years in a row. It seems like I vote against it every year for some reason, because I don't like some of the ones that...
Maybe this is your year, Representative Gentry.
Well, remind me again, in effect, what this is doing and why.
Yeah, it's
Talk to me like a freshman in high school.
But apparently you're one of the representatives that needed to stay awake for this today, so if you're going to vote against it. But what would happen if we found it deficient, that really holds no real power for us against the governor unless we find it null and void. So even though we find it deficient in the committee, that means nothing to the executive branch. They can move on about their business, implement the reg, and move on. So really the deficiency, all a deficiency does is really mark the reg. You know, we're putting a mark beside that reg, flagging it for the legislature when we come back into session, and basically telling everyone in the legislature, hey, we've marked this as deficient. What do we want to do about it? And for years and years, what would happen is the committee would find regs deficient, and then we get into session and nothing would be done about that particular reg. It would just flow on through, and the administration would do whatever they wanted to do. And so the administration would kind of thumb its nose, at the legislative branch. Republican and Democrat governors alike, not just one party. So that's the main purpose of it.
And what the language does is it strikes the language and prohibits the agency from reissuing the regulation, the same or similar language, for up to 1 year.
Yeah.
Representative All.
Just a quick question. Have you worked with the cabinet on this legislation? Do they have any concerns? I understand there's been conversations. Have you worked those out? Where do things stand with the cabinet itself?
So I had a conversation. I have a monthly conversations with, both of us do, with Secretary Freelander. We spoke to him yesterday, and he did inquire about this. And again, we're dealing with, I think it's just too big of a burden to require a master's degree, but he did express interest in negotiating with affected parties. So you might see something future, but yes, we have dialogue every month.
And on this particular reg, we had dialogue with them every month for 8 months. And we have to pick side at a certain point, and we picked the side that was not the cabinet in this situation because we understood and believed their testimony, which was you put this master's degree component on here, you're going to lose people. You're going to hollow out your rural workforce in this area, and so we felt that was very important to put a pause on it.
And if you've ever been around admin regulations, you will know that this is one of hundreds, if not thousands, that they found a disagreement on. So no further questions. We have a motion and a second. Clerk, please call the roll.
Representative All,
I'm going to pass today.
Representative Banta,
Yes.
Representative Callaway,
Aye.
Representative Kleins, Representative Dietz,
Yes.
Representative Donworth, Representative Pfister,
Yes.
Representative Flannery,
Aye.
Representative Gentry.
Explain my vote.
Yes, sir.
You're improving me. I'm going to go to a pass on this one. I do have some general concerns about crossing over that fine line. I understand your struggles. I understand what you had said, but there's also a fine line between crossing over that line where we're micromanaging what the executive branch is set out to do and supposed experts in their field setting regulations to administer the policies that we pass, laws which are generally more general and broad. I don't know the specifics of this particular thing other than what you just said, so I'm going to research that a little bit, talk to a few people, and see how I need to handle this on the floor. So thank you, Mr.
Representative Hampton,
Yes.
Representative Heverin, Representative Huff,
Yes.
Representative Jackson, Representative Kulkarni, Representative Meredith, Representative Neighbors,
Yes.
Representative Raymer,
Yes.
Representative Smith, Representative Wilson, Chairman Cook.
Yes. Bill carries. Congratulations. Look forward to hearing it on the House floor.
Thank you, Chairman, members
All
of the
right,
committee.
We have another senator with us today, former Representative Rollins. Now Senator Rollins, sir, if you want to come forward for Senate Bill 84. Representative Lewis, I believe you need to stay at the table. Then I'll let Mr. Bilby and Senator Rollins introduce themselves, and then we do have a committee sub.
Yeah, we have committee sub Steve Rawlings, Senate District 11. You want to introduce yourself again?
Yeah, Derek Lewis, State Rep District 90.
My name's Joe Bilby. I'm the Deputy General Counsel in the Speaker's office.
We do have a committee sub on that. Is there a motion on the committee sub? We have a motion and a second. All those in favor signify by saying aye. All opposed, nay. Committee sub passes. Floor is yours.
So the House Committee sub just strengthened the bill and added some whereas clauses to give a little bit of background and understanding where this bill originated from. And it came from the Loper Bright Enterprises versus Raimondo case in 2024, where the Supreme Court overturned Chevron. So it's ending Chevron deference. It's reaffirming that courts, not agencies, interpret the laws. The case it concluded that the Chevron doctrine was unworkable and unpredictable. The court majority concluded that the doctrine had been allowing federal agencies to expand their regulatory power beyond what Congress intended. Without similar protections at the state level, Kentucky agencies could still push their authority beyond what lawmakers intended, as has been the case on several occasions in Kentucky. This bill will restore judicial independence and will ensure that courts, not bureaucratic agencies, have the final say in interpreting the law. By limiting agency overreach, we are reaffirming the constitutional separation of powers and protecting the rights of Kentuckians. The repudiation of Chevron deference stabilizes state law and ends this arbitrary and undemocratic scheme. By passage of the bill, Kentucky State Legislature will reclaim its role in setting state policy and will remain the sole authority to create laws. So we as lawmakers pass the laws, the courts should interpret them. This would end the interpretations
Motion
of
on the bill.
agencies.
We have a motion on the bill and we have a second. Before we get to that, we do have two people here signed up to speak against. So gentlemen, I'd ask the three of you to step back, and then we have a Catherine Hargraves, okay, and we have Audrey Ernstberger. If you just come up, make sure your green light's on. It's kind of faint sometimes, so just make sure your green light's on. Introduce yourself for the record, and you may begin.
Good morning. My name is Audrey Ernstberger. I'm an attorney and lobbyist with Kentucky Resources Council. We offer environmental services across the Commonwealth for those who are downwind and downstream of environmental pollution.
It's Catherine Hargraves, very old former career staffer for the old Natural Resources and Environmental Protection Cabinet. So I am here on my own. I spent a career offering counsel, sometimes unwelcome counsel, so I'm here today to offer counsel.
Welcome back. The floor is yours. You may begin.
Thank you so much, members, for the opportunity to speak today and vocalize some concerns that we have about SB 84. KRC opposes Senate Bill 84 as an unconstitutional intrusion into the judicial function entrusted to a separate branch of government under the Kentucky Constitution. We believe that SB 84 interferes with the independence of the courts in constructing statutes, regulations, and agency orders where the public and workplace health, safety, and environmental quality are concerned. This tilts the scales of justice in statutory construction against public and environmental protection. In seeking to mandate to Kentucky's courts how to resolve ambiguities in a statute or regulation that is under review, and what standard to use in considering legal questions, and to prohibit the court from giving any consideration to agency interpretation of any statute, regulation, or order, SB 84 violates the separation of powers in the Kentucky Constitution, Sections 27. In Kentucky's Constitution, I read, in order that the independence of three distinct departments of government be preserved, it is an independent principle that the legislature cannot invade the province of the judiciary, and that the legislature cannot reduce the scope of the judicial function. This was in American Beauty Homes versus Louisville Jefferson County Planning Commission. There's also an inherent constitutional right to judicial review of any final agency action, and the General Assembly cannot impair that right. That was in another case, Kendall v. Baying. The General Assembly cannot dictate to the courts the scope of review. I do note that the de novo standard of review of matters of law that is in SB 84, and I don't know if that's still in the sub, but if it is, it might be acceptable since it's the standard that's already used by the courts. But the point would be that SB 84 doesn't add anything or removes nothing from the current court decisions and practice, and there doesn't seem to be a reason to codify that. SB 84's prohibition on courts giving any deference to agency interpretations of law or regulations is an unconstitutional infringement on the judicial function, and it's also inconsistent with state and federal jurisprudence. In Loper-Bright, which the sponsor mentioned, did discard the Chevron deference, it still does not prohibit any deference to a state agency's interpretation of any statute, administrative regulation, or order. Loper-Bright instead recognized that agency experience and expertise can provide important guidance in construction of statutes and regulations, but that courts themselves should not abdicate responsibility for determining what the law requires. The Loper-Bright court noted that an agency's interpretation of a statute cannot bind a court, but may be especially informative to the extent that it rests on a factual premise. The Loper-Bright returned to the test for deference that it had pre-Chevron, and that was the test in Skidmore versus Swift and Co. We consider that the rulings, interpretations, and opinions of the administrator under this act, while not controlling of the courts by reason of their authority, do not constitute a body of experience and informed judgment to which courts and litigants may properly resort for guidance. Prohibiting any deference to agency interpretations of law or its own or other agency regulations and that of agency orders as proposed in SB 84 is not in accordance with the U.S. Supreme Court decision in Loper-Bright or with Kentucky court decisions. The Kentucky Supreme Court noted in the Board of Education versus Hurley and Richards, issues of statutory constructions are matter of the law for the courts to resolve, and the reviewing court is not bound by an administrative interpretation of a statute. While Kentucky courts give deference to an agency interpretation of the regulations and the law underlying them, that does not rise to an abdication of the court's responsibility to finally construe the same statute or regulations. In matters of statutory construction, the courts have long held the ultimate responsibility. The General Assembly is without the constitutional power to mandate that where a reviewing court determines after applying rules of construction that any remaining ambiguity is to be construed against enlargement of agency authority. The interpretation of statutes is an inherent judicial function, and the General Assembly cannot constrain how the courts resolve ambiguities in the laws that they have passed, except by clarifying the intent of the intent and language of those laws by subsequent legislative action. Thank you for your time.
Thank you, Mr. Chairman. I want to get practical. I go back to the olden days. I predate Chevron. So to the bill itself, I don't know about the committee sub, but the version that I saw, it doesn't exactly say we're just not going to give deference to the agency. What it does is say if the agency has repealed or weakened a reg, that's okay. The court may rule favorably. If, on the other hand, an agency has written a reg or strengthened a reg, the agency automatically loses. Judicial review is judicial review. De novo is de novo. This is an effort to put the thumb on the scale for one side or the other. I don't think it will fly judicially. I don't think it'll go. I think it is a violation of separation of powers that's been discussed. But I want to talk more practically, because what Loper Bright has left you with, the legislature with, is really a great opportunity. You can avoid all the litigation, or at least almost all of it, simply by writing standards with specificity. Write them where you want them. And you've got two opportunities to do that. One is on the front end when you enact the statute. Two is when the reg comes before the two bodies, jurisdictional and administrative reg review. Instead of just saying, nope, deficient, go away, goodbye, that would be the time to say, our recommendation is agency, set the standard here. Give the agency some guidance, because agencies serve at your pleasure. You can keep them, you can abolish them, you can write their standards, you can defund them. The one thing you can't do is tell the courts how to interpret the law. It's the one thing you can't do. And my counsel to you today is bigger than that. We're all watching what's happening in Washington. The federal backstop that all state legislatures have relied upon for decades is going. It's going for at least the next 4 years. I think I won't see a change in my lifetime and the time I have remaining to me. My counsel to you is be careful, because there are a lot of people coming to you right now. They see that opportunity, knowing that the feds will not backstop. And it is going to be so easy for the states to make a race to the bottom. So my counsel is be careful. Be careful with these people coming saying, just here, a little there, let's drop this, let's drop that. And this, to me, Senate Bill 84 is just part of that larger package. So I appreciate the committee's time. That's all from me.
Okay, thank you. Any question for these two? Okay, ladies, if you'll step back. Gentlemen, I'll let you come back. Oh, Gentry, sorry. Ladies, stay 1 second. Representative Gentry has a question for you.
Thanks, guys. I'm sitting here trying to figure out when I walked into the Judiciary Committee. I'm not sure why we're even having this bill in this committee, but I guess my question is, Catherine, I think I heard you say you didn't think this is going to pass judicial muster. This sounds like a legal argument as a whole. Just a personal question. Do you think this bill should be in judiciary instead of licensing and occupations?
Yeah, hold on. We're not going to go there. That it's in here. It's here before.
I don't think half people in here even know what this.
No one cares what I think. I trust on that.
Thanks.
but
You're done. Thanks. Let's
All right, very
guys
good.
come
Thank
back up.
Representative Lewis would like to share.
Yes, sir.
First.
Thank you, Chair. So I guess we need to kind of go back through the history of this, and then to answer the other representative's question, I'll touch on it. Senator Rawlings had a good bill, I thought, and over the interim, myself and Mr. Bilby had several conversations regarding the Chevron decision, and I even had a bill to run it, made plans to run it, and my good friend in the Senate had a bill, so we thought we could take his bill and, like he said, strengthen it. So what we have before us does a few things in addition to the Senate, but it places a non-differential approach in three places. One, in Kentucky's Administrative Procedure Act covering rulemaking. One covering Kentucky's Administrative Procedure Act covering adjudications. And then also a chapter of statutes that explains how statutes are to be interpreted. So whether it's the laws we pass or the regulations that come before us, which is a subcommittee of this committee, that is why we are here. Now, whenever I pass a bill, and many of you pass bills, and we want our intent to be followed with that bill. We don't want it to be misconstrued. Same things on regulations, and that's what my subcommittee does, is if maybe an agency is maybe taking a stronger stance than what the legislature was initially intended or what we believe the legislature intended, we take issue with that. We won't, whichever party you belong to or whatever you are pushing, if we pass a bill, we want the legislature's intent to be followed. Now, as for the technical questions, I will hand it off to Mr. Bilby.
Okay. I just want to clarify for the members, there was some discussion a moment ago about the version of the bill that passed out of the Senate containing a provision that said that to the extent there is any remaining ambiguity, we, the legislature, are directing the courts to construe that ambiguity in a way least favorable to the expansion of agency power. Just so you're not confused, that provision does not appear in the version of the bill that is before you in the House Committee Substitute. And the rationale that Representative Lewis and I played with in our minds and spoke about with Senator Rawlings was that, our hope is that the judiciary presses itself to reach the very best interpretation of the law every time. Not just to say, well, we've come this far and there's 3 or 4 possible interpretations that are all reasonable, and so we're just going to defer to the agency's choice of which of those 3 or 4 interpretations they wish. That sort of deference has played out on the federal level in a pendulum effect, where one administration will take office, interpret a statute one way, and then the next administration will come along and interpret it in a different way, and what you end up with is regulatory policy that swings back and forth every 4 years or every 8 years. That's not what this body expects, I believe, in terms of policy making. And so the point of this bill, or one of its aims anyway, is to press courts to do their jobs fully, to make their very best interpretation of the law as written, and go with that, instead of taking a step back and saying, well, the agency has some special expertise that we, the courts, don't have, so we're going to let them be in the lead. We believe that far from taking away power from the judiciary, as one of the previous speakers suggested was the point of the bill, is in fact the opposite. We're seeking to empower and strengthen the role of the judiciary, because it is their function to say what the law is and to interpret the words of the bills that you pass here. And so we don't see it as a power grab in any way from the judiciary. It's instead an effort to properly restore it to its role as the arbiter of what the law is. With that, Mr. Chairman, I'll pause and.
Yep. I think we have a question from Representative All.
Thank you, Mr. Chairman. I'm reading the page 3 of the proposed House sub here. It says the court shall apply instead of may. To me, that is kind of putting a thumb on the scale of the judicial system and telling them what they have to do instead of what they can do. Can you explain why this is a shall instead of a may?
Well, from my perspective, it's because the view of the bill sponsors and my hope is the view of the General Assembly is that you believe that the judge shall apply de novo review to any agency's ruling or view of a question of law, that they should not have the option of stepping back and saying, well, here's one of 4 or 5 reasonable interpretations. That's good enough for us.
Any further questions? Representative Kulkarni.
Thank you, Chairman, and I apologize for coming in late. I was presenting in another committee, so I missed the presentation. I'm going to echo, I think, some of the concerns that folks have espoused in this committee. Primarily, just looking through the bill, page 1, line 16, the whereas, the General Assembly does not believe that any state agency possesses a proficiency in interpreting a statute that is superior to that of the Court of Justice. And taken together with some of the language on page 2, lines 1 through 5, specifically that the administrative body shall not interpret a statute with the expectation that the interpretation is entitled to deference. But then in subsection 2, it states the interpretation of a statute or administrative regulation by that administrative body shall not be entitled to deference from a reviewing court. And I just heard you mention, Mr. Bilby, that the courts should not have the option to do that. How do you, taken together, how do you explain how this is not an intrusion into our judicial branch, unconstitutional intrusion into the judicial branch, and also how do you expect that a judge is going to be able to provide a correct and accurate interpretation without going back and looking through exactly what you're saying that they shouldn't look at in providing that interpretation?
Well, to be clear, ma'am, we're not saying, and I don't think this bill suggests, that a judge can't listen to a cabinet's arguments about what the law is. Of course they can. That's the gist of Skidmore deference. An agency's view is only as persuasive as the strength of its arguments. So if they come forward with a really good argument about what the law is, the judge should take note of that and say, this makes a lot of sense. I think that their interpretation of law is not just reasonable, it's the best interpretation of the law. But if their arguments are weak or not as good as those of the competing views that are presented, then the judge should say, I don't think the cabinet's right here. I think the cabinet's wrong, and I read the statute in this other way, and that is my single best reading. So this statutory language is directing agencies to understand that when you promulgate a rule, a forward-looking general application rule, don't do it with the expectation that a judge is going to step back and say, well, that sounds reasonable enough to me. And by the same token, we hope that a judge would read this language in a statute in some future case, a year from now or 10 years from now, and say, yep, I'm confident that I'm empowered and capable and proficient in interpreting statutes, and the General Assembly is confident that I am too. And I don't have any reason, contrary to a couple of decisions of the Supreme Court in the pre-Loper-Bright era, I don't have any need or requirement to step back from that duty, to give my best interpretation of what the law is.
Thank you, Chairman.
Okay, we have a motion and a second. Clerk, please call the roll.
Representative All.
Briefly explain my vote, Mr.
Yes, sir.
Chairman. I think, empowered or not, the fact that we are mandating an interpretation of judiciary is a constitutional violation. I'm not an attorney. That's coming from people that I trust that are, and in deference to what one of our fellow members of the General Assembly said on the floor recently, that the legislature is the most powerful branch of government, we should have 3 equal branches of government, and I think this is putting the thumb on a judiciary branch on my no today.
Representative Banta.
Yes.
Representative Callaway.
Aye.
Representative Kleins.
Yes.
Representative Dietz.
Yes.
Representative Donworth. Representative Pfister.
Yes.
Representative Flannery.
Yes.
Representative Gentry.
No.
Representative Hampton.
Yes.
Representative Hebron. Yes. Representative Huff.
Yes.
Representative Jackson.
Yes, ma'am, and report my attendance, please.
Yes. Representative Kulkarni.
Briefly explain, Mr. Chairman. Yes, ma'am. I'm a no today, and again, I reviewed the legislation prior, obviously, to this committee. My concern is with the strength and the extremity of the language. Shall not, cannot, defer, cannot look at anything that an agency has interpreted or promulgated before in making a decision. And I understand that a judge may feel empowered, the legislature may feel empowered, we may all think we know exactly what is going on in a specific regulation or statute, but that does not mean that we have the technical expertise or the subject matter expertise to actually justify that feeling of empowerment. I think that this is a dangerous piece of legislation if we are not willing to maybe look at some of the very, very specific language that is prohibitive rather than permissive. So I'll be a no today, and I'm hoping that I can speak with the sponsors to discuss some of those specific changes, just to make it a little bit less prohibitive for our judges. Thank you.
Representative Meredith. Representative Neighbors.
Yes.
Representative Raymer.
Yes.
Representative Smith. Yes. Representative Wilson. Yes. Chairman Cook.
Yes. Bill carries. All
Thank you, Mr. Chairman and committee. Appreciate it.
Thank you, gentlemen.
Thank you, Mr. Chairman, members of the committee.
All right, Representative Banta, House Bill 324.
Chairman, you want me to do it now or later?
Representative Kleins, you want to register attendance and a vote? And
Yes, please. Thank you, Mr. Chair. I'd like to obviously recognize my presence and vote yay on House Bill 90 and yay on Senate Bill 65.
Representative Kulkarni.
Thank you. I'd also like to record my presence, a yes on House Bill 90, a pass on Senate Bill 65.
Representative Jackson, were you here for all of them? Or would you like to record a vote? Okay, yes, sir.
Representative Kim Banta, District 63, and I'm going to let my guests introduce themselves.
Representative Tina Bojanowski, District 32.
Mike Kleins, Kentucky State Representative, District 68.
Welcome. The floor is yours.
Thank you. So you have public school, private school, public school, all represented here. This bill came from a committee that I was in over the summer where a district said that they are going to lose a lot of instructional aides and some teachers due to the praxis. I started discussing it with Superintendent Kleins at the time and my friend, Representative Tina Bojanowski, and we said, how often did we ever use the praxis as a guidepost to hiring or keeping a teacher? And the answer is never. It's another rung of the ladder that someone who has a 4-year degree from an accredited university, which we should accept if we think that our universities are doing a good job, that they have to shell out more money, more stress, and take a test in order to go into the field of education. Oh, sorry, you're so. I have a motion on the bill, so I'm going to stop talking.
Representative All.
Briefly explain.
Yes, sir.
I had to go through that. I had to pass the praxis. It was grueling. Excited to be a guest today. Thank you for this bill.
Representative Banta.
Yes.
Representative Callaway.
Aye.
Representative Kleins.
Yes.
Representative Dietz.
Yes.
Representative Donworth. Representative Pfister.
Yes.
Representative Flannery.
Yes.
Representative Gentry.
Yes.
Representative Hampton.
Yes.
Representative Hebron.
Can I quickly explain my vote?
Yes.
I'm a yes today. Thank you. I was just telling my page here, Jack, I think it's really important to note that this is a bipartisan bill. And so whenever we come together and work on things, we always get good outcomes. So I appreciate that, especially in education. So thank you.
Representative Huff.
Yes.
Representative Jackson.
Yes, ma'am.
Representative Kulkarni.
Yes.
Representative Meredith. Representative Neighbors.
Yes.
Representative Raymer.
Yes.
Representative Smith. Yes. Representative Wilson. Yes. Chairman Cook.
Yes. House Bill 324 passes.
Thank you so much, everyone. Have a great day.
Thank you. Representative Freeland, House Bill 449.
Chairman Cook, I'd like to.
Callaway, you want to register attendance? And
Yes,
some votes?
please. I
ahead.
don't think I missed any votes, but
Did you
just
make House Bill, the birthing center, House Bill 90?
Oh, yes, I'm an aye.
Yes on 90.
Thank
Okay.
you.
Got it. And Representative Wilson.
Yes, I apologize. I had to present the other committee. I'd like to mark my presence and a yes on all the bills.
I got to do them one at a time. So I'll just ask you, House Bill 90,
Yes.
Senate Bill 84,
Yes.
Committee Sub, and Senate Bill 65.
Yes.
And were you just here? You were here for 324 just now, right? Okay, good. We're caught up. Anybody else? Representative Freeland, introduce yourself for the record. Floor is yours.
Thank you, Mr. Chairman, ladies and gentlemen. I want to keep the good bipartisan feeling going, so you can back up. But appreciate the opportunity to bring you House Bill 449 this morning. I know it won't come to a shock to anyone to hear that we have a massive access to care problem when it comes to dental care needs for our kids here in Kentucky. However, there is one bright spot, and that's the innovative and wonderful work being done by the University of Louisville School of Dentistry and the University of Kentucky's College of Dentistry. Both have done innovative work and go above and beyond to help fill a provider void in this state with community dental clinics, mobile dental teams, and at times provide free dentistry to the community, and also other things like school mobile dental outreach teams that visit our public schools all throughout Kentucky. And these teams were established almost 2 decades ago and are still going strong today. And from satisfying the school's required dental screenings, they also do exams, cleanings, fluoride treatments, sealants, education, and importance of preventative care. And many times it's the first time the student has ever seen or heard about oral care. In addition to this, they also do the work with the Friskies to make sure that these students, if they find any oral issues, that they are seen by a dentist, that they they check to make sure follow-up work is done. So what? Oh.
Representative All.
Yes.
Representative Banta.
Yes.
Representative Callaway.
Aye.
Representative Kleins.
Yes.
Representative Deeds.
Yes.
Representative Donworth. Representative Pfister.
Yes.
Representative Flannery. Representative Gentry.
Yes.
Representative Hampton.
Yes.
Representative Hebron.
Yes.
Representative Huff.
Yes.
Representative Jackson.
Yes, ma'am.
Representative Kulkarni.
Yes.
Representative Meredith. Representative Neighbors.
Yes.
Representative Raymer.
Yes.
Representative Smith. Representative Wilson. Chairman Cook.
Great program, great idea. I'm a solid yes. House Bill 449 passes.
Thank you, ladies and gentlemen.
Okay, at this point, I'm going to make my way down to the table, turn the chair over to Representative Smith. And while I'm going down there, I think Representative Neighbors would probably like to make an announcement about, you're going to talk about tennis shoes tomorrow?
Sure. I'll take this opportunity to relay to everyone that tomorrow is Suits and Sneakers Day at the Capitol. This is to raise awareness for cancer, so I encourage everyone to wear your comfy sneakers tomorrow with your suit. So hope that everyone will participate. Thank you.
Okay, Mr. Chairman, go ahead and introduce yourself and your guest.
Good morning, Matt Cook, State Representative, 72nd District.
Good morning, Shannon Stiglitz, Senior Vice President of Government Affairs for the Kentucky Retail Federation.
Make sure
it's on.
No.
Representatives, Louisville, Kentucky, representing the Kentucky Auctioneers Association.
You may proceed.
All right, good morning. So we're always, every year, we try to combine our alcohol bills, so there is a committee sub on this.
Okay.
Second.
Got a motion and a second. All in favor say aye.
Aye.
All opposed? You may proceed.
Okay, committee, we do two things here. The first is retail to restaurant. So right now, and I don't want to call any alcohol an emergency situation, but right now you'll have a restaurant, they'll run low on alcohol, and I'm going to use an example here. We actually had a bus load of people from Pennsylvania show up at a local restaurant, small town, and they all drank Yingling beer. And so the restaurant wanted to go out and be able to purchase this and serve them. So we have simply opened up a pathway where they can go to a local retail establishment and purchase that. We put the limits are in here. It's a small amount, just somewhere if they have that situation, they can run out and purchase that. All that alcohol is still going through the 3-tier system, everything on that. So that's the first part of this bill.
Motion on the bill.
No, well, yep, go ahead. That's the first part, and then their second part is dealing with auctioneers. So we have a lot of estates. People have pretty significant collections of alcohol that they want to be able to move. So they get a temporary auction license. It's $100. It's good for 30 days, which they can have one auction with that. The alcohol has to be previously sold at retail. It has to be its original packaging. They can ship it. These are going to be auctioned. Some of these bottles will bring some money, so we put in the provisions that they can ship that alcohol, but they cannot ship into any dry territory. I know that always comes up. And then they have to report the details of that, what it was, original packaging, et cetera, who bought it, who sold it, et cetera, has to get in there. They have to have a copy of the license posted, anything you would have. I think it's also important to note that the auctioneer cannot hold any other alcohol license. So this cannot be a liquor store hosting their own auctions.
Okay, we have a motion on the bill. Do we have any questions first? Okay, do we have a second? Second. We got a second. Madam Clerk, go ahead and call the roll.
Representative All.
Yes.
Representative Banta.
Yes.
Representative Callaway.
Aye.
Representative Kleins.
Yes.
Representative Dietz.
Yes.
Representative Donworth. Representative Pfister.
Yes.
Representative Flannery.
Yes.
Representative Gentry.
Yes.
Representative Hampton.
Yes.
Representative Heverin. Representative Huff.
Yes.
Representative Jackson.
Yes, ma'am.
Representative Kulkarni.
Yes.
Representative Meredith. Representative Neighbors.
Yes.
Representative Raymer.
Yes.
Representative Smith.
Yes.
Representative Wilson.
Yes.
Chairman Cook.
Yes.
Okay, the bill passes favorably. We have a title amendment on this bill. I need a motion on the. Motion on the title amendment. You got a second? All in favor, say aye.
Aye.
All opposed? Okay, the title amendment is added, and the bill's passed, and so shall on the floor.
Representative Smith, if you'll introduce yourself for the record, you may begin.
Thank you, Mr. Chairman. I'm Tom Smith from the 86th District, and today I have a bill before you, 710, that it's, I apologize it being a shell coming in, but we had to get it to make sure that we could get the language right and get it approved. But it basically, the quickest way to explain it, a doctor has several clinics, and he has people that work under him, nurse practitioners who have the ability to prescribe. And over the years, we've given them more and more leadway where now they can prescribe scheduled drugs. Well, in the instance, one of the nurse practitioners decides to run a pill mill. Well, the doctor is ultimately responsible, but he's not in the facility with them, but he still signs off on all of his nurse practitioners. And he goes down with it. The DEA comes in, takes the license, takes the nurse practitioner, and also takes the license of the doctor. Even though he wasn't hands-on, it was still his responsibility. The doctor then has the ability to go back to the medical board and reapply for his license and go through all the hoops that it takes to do that, which is years and a lot of tape to cover. And he's successful in getting his license back, except in the state of Kentucky, we had a law. If you'll go with me to page 5, standing law that said lifetime ban on pharmaceutical license, like being able to write pharmacy. In seeing this, I thought that was extreme due to the medical board being able to give a license back. But the DEA was using this lifetime ban, saying there's no sense in applying back to us because Kentucky has a lifetime ban. So the wording in it basically, in page 4, it just basically takes the lifetime permanent ban out of there and puts the word may. They still have to go through federal DEA to get their license. They can still be turned down. It can be no the rest of their life, but at least they have the due process to be able to ask. And that's all that I've done is change that from permanent to may. And again, we can't tell the federal what to do, but we can at least let them not use our language to permanently ban them the rest of their life. So I think this is a just bill. It's fair. And again, there's 2 steps they have to take: the medical board to get their licensing back, but the pharmaceutical board pharmaceutical license is important for them to be able to practice, as you know, as a doctor. So that's the gist of it.
Let's go. First, we have a committee sub. So
Yes, sir.
All in favor? We have a motion on committee sub. Second. We have a second. All those in favor signify by saying aye. Aye. All opposed, nay. Committee sub's on the table, and we have 2 questions.
Okay.
Representative All.
Thank you, Mr. Chairman. Representative, in your testimony, you said you acknowledge that the physicians who are running these clinics ultimately have the responsibility and they have to sign off on this.
Yes, sir.
On this activity.
Mhm.
And it's also their responsibility, even though they may not physically be present, to know what's going on in their clinics, right? They have to review the billing and what they're doing and understand what their business is doing.
Mhm.
My question is there a particular situation or a justification here that you're aware of, an instance where we would need to lift that permanent ban when that physician has advocated their responsibility and not taking a proactive approach in managing their clinics?
Yes, sir. The 2 incidences that I know of personally, I don't want to get into their cases, but they were charged with we consider a pill mill, where the nurse practitioner was actually selling on the outside. And when they caught them, they came in, and that's the ability that they have, is to go to the superior who signs off on it, and that is the doctor. And so I'm not condoning the practice. What I'm saying is the doctor still has to get his license back, has to go before the board, the medical board, has to go through all the steps that they give them to go by to get their license reinstated. They've gone through all that, and the board found them it's sufficient for them to practice. The only issue for practicing as a doctor is you need to be able to prescribe. So that hindered them from going back into practice. Not that they couldn't. The Board of Medical Licensing had given their license back. I just think that it still should be a due process, Representative, that they can still go and apply. we're not saying that they shall be given their license back, because we can't dictate federal, but it gives them the opportunity to go back and to apply for their pharmaceutical license. Again, they can be told the rest of their life, no, you're not going to get them by the DEA. I'm just saying our language in our law was permanent, and I didn't think that was fair. I'm just taking the permanent out and saying may, because if you've ever dealt with the federal side of it, they're using our language against our own people, our own law. If it's changed, then they can't use that. They have to at least look at it as a due process and let them go through the process. Does that make any sense there on that?
I understand what you're saying.
Yes,
I may
sir.
not agree with what you're saying,
Okay.
but I understand what you're saying.
Okay.
Thank you, Mr. Chairman.
Clerk, please call the roll.
Representative All.
I'm going to briefly explain my vote, Mr. Chairman.
Yes, sir.
I think the permanent lifetime ban is a good deterrent. You know, I think the physicians in that space are ultimately, to your testimony, they are responsible for their practice and their clinics. I don't care how big they are or how small. End of the day, it's their responsibility. And they will be less likely to go down this route again if they know that this automatically will be a lifetime ban from this type of practice. So I think the law as it sits today adds a different stick to determine for this type of activity. So I understand your reasoning. I just think it's so no. I think it's a dangerous path for us. No.
Representative Banta.
May I explain my vote, Mr.
Yes,
Chairman?
ma'am.
Thank you. I'm going to be a yes on this measure, and this is why. It's not because I agree with what they did. It's not because of, I think everyone deserves to be rehabilitated. I vote for every single rehabilitation bill. I vote for giving back voting rights. I do all of that, and this to me is the same vein that a person made a mistake. They have to go through all the procedures again. Most likely the DEA is going to say no anyway, but at least Kentucky is not holding something back, and we are in the spirit of forgiveness and redemption. Thank you.
Representative Callaway.
Aye.
Representative Kleins.
Yes.
Representative Dietz.
Yes.
Representative Donworth. Representative Pfister.
Yes.
Representative Flannery.
Yes.
Representative Gentry.
Explain my vote, please.
Yes, sir.
My explanation is kind of a combination of Representative All and Representative Banta. I am too a second chance kind of person on a variety of issues, and if there's a way to fully rehabilitate someone and make them a positive contributor to society, I like that. What I don't like is the way we're going about this. Basically what we're doing is we're saying you may put a ban on, you may not. And that's it. Nothing else is really addressed here. I would like to see us have the ban in there and provide a pathway in certain situations and have that kind of language in there. I'm going to be a no today, but I appreciate what you're doing and the intent you're trying to accomplish. I think this opens up some potential unintended consequences, and I would like to see that other path. Thank you.
Representative Hampton.
Yes.
Representative Hebron.
Yes.
Representative Huff.
Briefly explain my vote, please.
Yes, sir.
I'm voting yes because I believe it's exactly what it's doing is providing a pathway. Thank you.
Representative Jackson.
Yes, ma'am.
Representative Kulkarni.
Yes.
Representative Meredith. Representative Neighbors.
Yes.
Representative Raymer.
Yes.
Representative Smith.
Yes.
Representative Wilson.
Yes.
Chairman Cook.
Yes. House Bill 710 passes.
Move for the clincher.
Oh, sorry. We didn't move for clincher. We don't need to do clincher. We need to do the title. We do need to do a title amendment. So if there's motion on title amendment, is there a second? We have a motion and a second. All those in favor signify by saying aye. All opposed, nay. 710 passes. We're adjourned.